Appeal Aspects Contract Limited and Higgins Construction plc.
Adjudication is a convenient procedure introduced by implication into construction contracts by the Housing Grants, Construction and Regeneration Act 1996, read with the Scheme for Construction Contracts, England and Wales Regulations 1998. It enables a party to a construction contract who maintains that the other party has broken the contract to obtain a speedy interim decision from an adjudicator. The decision of the adjudicator is then, quote, binding until the dispute is finally determined by legal proceedings, by arbitration, or by agreement. It is clear, therefore, that a party who gets an adjudicator's decision in their favour can bring proceedings to recover more, and that a party who pays money under an adjudicator's decision can bring proceedings to get it back, in each case by showing in the proceedings that the actual contractual position was different from that decided by the adjudicator. This appeal raises the question when and how the 6-year limitation period runs in relation to each such claim. Aspect contracted with Higgins to survey and to report on a block of maisonettes which Higgins was considering redeveloping in 2004-05. Aspect's report was dated 27 April 2004. During the redevelopment in 2005, Higgins allegedly discovered asbestos material not identified in Aspect's report, and a dispute arose which Higgins submitted to adjudication, claiming £822,000 odd. On the 20th of July 2009, the adjudicator awarded £490,000 odd plus interest, putting that as due in contract and or tort. The tort claims being coterminous with the contract. And on the 6th of August 2009, Aspect duly paid some £658,000. Higgins did nothing to pursue the balance of its claim, and any claim by Higgins to that balance became on its face time-barred after 6 years on or about the 27th April 2010 in contract and sometime in 2011 in tort. On the 3rd of April 2012, Aspect, without prior warning, started proceedings to recover the £658,000 it had paid, plus interest, on the basis of an implied term or in restitution. The judge, Mr. Justice Aikenhead, held that Aspect's claim to recover the money it had paid became time-barred at the same time as any claim by Higgins to recover the balance, which it had claimed, in other words, in 2010 or latest 2011. This was on the basis that Aspect could have claimed a declaration of non-liability at any time from 2004 or 5 onwards. The Court of Appeal reversed the judge and held that Aspect had, by implication, 6 years from the payment it made to recover the sum paid. No claim in restitution was advanced before the Court of Appeal. The Supreme Court unanimously dismisses the appeal in a judgment given by myself. It considers the position both in relation to the contract position and in restitution. It rejects Higgins' submissions that Aspect's only claim was for a declaration of non-liability, and that having obtained such a declaration, Aspect could then have obtained a consequential order for repayment of money without having any independent basis for such a claim. It also rejects Higgins' submission that any claim by Aspect for a declaration of non-liability in contract or tort would have become time-barred after 6 years from the accrual of any cause of action which Higgins acquired to recover for damages for breach of contract or duty by Aspect. In the Supreme Court's view, Aspect acquired an independent right to repayment of the money it repaid as a matter of implied contract or alternatively in restitution upon and by reason of the payment it made, provided and to the extent that it could succeed in having the original dispute resolved in its favour in the proceedings which it brought to recover the money it had paid. The 6-year period for any such claim by Aspect ran from the date of the payment, in other words, from the 6th of August 2009, so that Aspect's proceedings begun on 3rd of April 2012 were in time. In contrast, the 6-year period for any claim by Higgins to the balance of its claim ran from the date of the original breach of contract and or tort alleged by Higgins, in other words, from the 27th of April 2004 or sometime in 2005, and Higgins was and is therefore out of time after 2010 or 11 for pursuing such balance. Higgins complains that this result gives Aspect a one-way throw. Aspect could improve, but not risk worsening its position by delaying its claim until after the time limit had expired for a claim by Higgins to the balance. But this consequence flows from the nature of adjudication as a provisional determination and from Higgins' own decision not to commence proceedings to confirm the adjudication decision which it obtained, coupled with the fact that Aspect never agreed to treat that decision as final.